Tonight, we begin with a development that immigration attorneys, policy experts, and advocacy organizations had anticipated, debated, and prepared for. A guidance that unfolded not over months of deliberation, but in a single coordinated release. A single day that altered the processing timelines for thousands of pending applications. A single day that redefined enforcement priorities across multiple agencies. A single day that sent immigration courts, consular offices, and legal aid organizations scrambling to understand the new landscape. What the White House did today crossed a line that immigrant rights advocates had hoped would hold. And when that line broke, legal organizations did not hesitate. They responded with urgency, precision, and coordinated action. For 6 months now, there had been signals. Not official announcements, not formal policy papers, just signals that the administration was preparing something consequential. The White House has been deliberate, yes, but they have been strategic in their deliberation. Their moves have followed a certain pattern, a rhythm, almost a choreography. But what set off alarm bells in Washington and immigration law circles this week was that the pattern went silent. Immigration lawyers who monitor policy shifts know the indicators, the leaked draft memos, the closed-door meetings with DHS officials, the sudden personnel changes at USCIS, the abrupt cancellation of stakeholder briefings. All of that went quiet. And whenever the White House goes quiet on immigration, it means something is about to get loud. Early Monday morning, the Department of Homeland Security detected what they described as comprehensive policy realignment, including enforcement mechanisms that had not been deployed in over 3 years. These are the kinds of procedural changes that the administration only implements when they are signaling something very specific. A shift in priorities, a response to political pressure, or a fundamental restructuring of the immigration system. Immigration observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the White House was changing posture. And when federal agencies shift immigration policy without extensive public comment, even by seemingly small measures, attorneys and advocates pay attention. The guidance issued by the White House tonight was not normal. It was not routine. It was not symbolic. It was urgent. Legal experts, after emergency conference calls, described the administration's move as legally questionable, procedurally rushed, and perhaps, most importantly, designed to take effect before courts could intervene. But policy only works if the affected parties hesitate. Immigration advocates did not. In fact, their response today was among the most coordinated we've seen in recent immigration policy battles. Here's what we know. Within hours of the guidance release, major legal organizations filed preliminary injunction requests. These weren't the standard legal challenges. These were emergency petitions, legal mechanisms that advocacy groups only deploy when they are preparing to halt enforcement before implementation. Tonight, sources confirmed that immigrant rights organizations launched coordinated responses on multiple fronts, including emergency hotlines that had recently been established for what analysts believe was exactly this scenario. Attorneys mobilized before the administration could begin processing cases under the new framework. They filed in the Ninth Circuit. They filed in the Second Circuit. They filed in district courts that were likely preparing to hear related cases. In other words, advocates targeted the legal infrastructure, the procedural mechanisms that would have made the guidance operational. This is what made legal experts' warnings so urgent. The White House's guidance wasn't just symbolic, it was actionable. It represented the kind of policy shift that could affect thousands of pending cases if left unchecked. And immigration attorneys, understanding that fully, responded with force, not recklessly, not impulsively, but strategically. They didn't challenge every provision. They didn't file in every jurisdiction. They hit the most vulnerable aspects of the guidance. They hit the enforcement priorities most likely to be deemed unlawful. And here's where the story becomes even more complex. Legal analysts now believe that the White House's latest guidance was designed to test the strength of judicial oversight after recent Supreme Court decisions on immigration enforcement. The administration wanted to see whether courts would intervene quickly, but instead, the opposite happened. Federal judges didn't delay proceedings. They scheduled emergency hearings that were so swift, so unprecedented, that even White House counsel noticed. You don't get the administration's attention easily on procedural matters. But today, the judiciary did. Immigration scholars speaking with media under anonymity described the White House's approach as strategic escalation, a way to establish new precedents. But the courts proved today that they remain both vigilant and independent. Their responses were not only rapid, they were calibrated so precisely that preliminary orders addressed specific provisions without blocking the entire guidance. That precision matters because it shows judicial sophistication. It shows that federal courts are not simply blocking policy. They are engaging with substance. As reports continued coming in throughout the evening, we learned more about the scale of the legal response. The American Immigration Lawyers Association carried out nationwide attorney alerts, forcing emergency consultations with thousands of clients. The ACLU targeted provisions that had been flagged in preliminary legal analysis in the last 72 hours. Community organizations operating in sanctuary cities reportedly activated rapid response networks used by immigrant communities to understand their rights. This wasn't just legal maneuvering. This wasn't just policy disagreement. This was coordinated resistance. This was institutional pushback. And institutional pushback is the one thing the administration has struggled to overcome since taking office. For every enforcement priority they have announced, advocacy networks have countered with something that complicates implementation. Remember, the administration thought federal courts would defer to executive immigration authority. They thought advocacy organizations would need months to organize responses. They thought the guidance would be implemented before legal challenges gained traction. But tonight, the exact opposite is happening. Courts are scheduling emergency hearings. Organizations mobilized within hours. Legal challenges are already impacting enforcement planning. What makes this moment so significant and so volatile is that the White House's latest guidance happened at a time when the administration is under mounting political pressure. Conservative immigration hawks want stricter enforcement. Business coalitions want expanded visa categories. Immigrant advocacy groups want protection from deportation. Congressional Democrats want legislative solutions rather than executive action. The administration is balancing these demands while facing legal challenges on multiple immigration fronts. And when administrations in that position make sudden policy moves, they're not doing it from strength. They're doing it from pressure. They're doing it from vulnerability. The White House's guidance, now circulating through federal agencies, was designed to signal that the administration is not willing to maintain current processing timelines and enforcement priorities. Officials said plainly that existing procedures were inconsistent with national security and border integrity. That is bureaucratic language for, we're changing the rules and we're doing it now. You don't usually hear that tone from the White House on immigration policy unless something serious is at stake politically. Meanwhile, the Secretary of Homeland Security addressed reporters in a brief, carefully worded statement tonight. He said, "These measures represent necessary adjustments to ensure orderly immigration processing." He said, "We remain committed to lawful pathways while enforcing our borders." And he said, "These changes will take effect immediately pending any judicial review." These are not rhetorical flourishes. These are statements from an administration that understands just how high the political stakes have become. Here's what makes the situation even more concerning. The White House's latest guidance wasn't isolated. Along with visa processing changes, ICE also announced expanded enforcement operations. USCIS revised family-based petition procedures. State Department consular offices increased interview requirements, targeting visa applicants from specific countries. All of this happened within the same 48-hour period. When the administration moves multiple policy pieces at once, it means something larger is underway. Legal analysts are now considering several possibilities. One is that the administration is preparing a broader immigration enforcement campaign. Another is that the White House is attempting to establish precedents before the 2026 midterm elections. A third possibility, the one worrying advocates the most, is that the administration is attempting to fundamentally reshape asylum and refugee processing. But today, immigrant rights organizations took that card off the table. They didn't wait for implementation. They didn't organize slowly. They didn't limit their response to public statements. They filed emergency legal challenges. What we're watching now is a test of institutional resilience. The administration wants to see how quickly it can implement policy changes. Advocacy organizations want to show they can respond in real time. Federal courts want to prevent constitutional violations. And immigrant communities want to prevent family separations and deportations. Tonight, we've heard from immigration attorneys who are now conducting emergency consultations with clients. They say applications should be filed immediately under current rules. They say anyone with pending cases should seek legal counsel. And they say the administration's decision to issue guidance without notice and comment rulemaking is likely part of a broader strategy intended to avoid prolonged legal challenges. But advocacy networks are not disorganized. In fact, they are mobilizing nationwide. Their response today, coordinated, sophisticated, and legally sound, sent a message to the White House that immigrant communities have robust legal representation. And it sent a message to federal courts that constitutional questions require immediate judicial attention. As the week goes on, we expect more details to emerge about what exactly the administration hoped to achieve. But what we do know is that the legal community's mobilization was timely. It protected pending applications from immediate jeopardy. It preserved legal pathways for vulnerable populations. And it demonstrated that policy changes affecting millions cannot be implemented without scrutiny. What happens next will depend on what federal courts do in the next several days. If they grant preliminary injunctions, this moment will be remembered as successful judicial intervention. If they allow implementation, advocacy organizations have already shown they are prepared for prolonged litigation. They have shown they are ready to respond. And tonight, for the first time in months, the administration appears to be recalculating. Immigration policy offices are quiet. Too quiet. And when the White House is quiet after major guidance releases, it means they are assessing judicial response. It means they are choosing their next move carefully. Because tonight, the administration learned something they have learned before. Immigration policy cannot be changed by executive fiat alone. Legal institutions remain independent. And immigrant communities have advocates who respond with speed and precision. This story is far from over. But tonight, one thing is clear. The guidance has been issued. The legal challenges have been filed. And the courts will decide whether this policy stands or falls. And we will be here, watching every detail as the next phase unfolds.